You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my rights.
See how much authority I have. The court does call the case of the people versus Daniel McGough.
Good morning, Your Honor. Ashley Lottie for the people.
Sir, state your name.
I'm here on a special appearance, Your Honor. McGough's is Easy Elastical Trust, registered in Jackson County, under case number 2522246.
Okay, is your name Daniel McGough?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Mr. McGough, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No. Not at this time.
Let me then do this. You have two cases before this court, one being the case ending, let me get the full number, case number 25F40523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be charged with something without a witness.
Your other cases when you represent yourself, so we'll just do it.
Are you talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up to 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services.
As I am here and as a trust, Your Honor, I am here in exclusive equity. Exclusive equity.
You count 2 on that complaint is the charge of operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization.
My license is
Count
canceled,
3.
not suspended or revoked. It is
Count 3
canceled through the state
on
of
that
Michigan.
complaint
Canceled.
is the charge of escape from lawful custody. That is a misdemeanor punishable by up to 1 year, a $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by
wishes
Washington
to
County
represent
prosecutor as
himself.
usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply.
This is a matter under the Eastern District of Michigan Federal Court. Case number 2511226.
I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel will be appointed to represent you. Because of the defendant's conduct in the past, in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. McGough has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25F30979, in that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count 1 is fleeing and eluding 4th degree.
Added on by the prosecutor's office after the fact.
That is a felony, punishable by up to 2 years incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
My Secretary of State, anything is canceled. I have no contracts with the state of Michigan.
That is a misdemeanor
This
charge.
is a matter of trust, Your Honor. This is a matter of trust. I am protected under a
90
trust.
days in jail, a $100 fine plus court costs. Count 3 on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court costs. Count 4 is operating while license suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are through the federal government. I have federal government
$500 fine
registration.
plus
I do
court
not have
costs.
contracts with the
Vehicle could
state.
be subject to mobilization. Count 5 on that complaint alleges refusal to obey refusal to
I have an international driver's
police
permit.
officer. That is a misdemeanor punishable by up to 90 days, $100 fine plus court costs. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I stated in the other case also apply to this case.
Were you served your
And that
notice
if
and
the
summons yet, Your Honor?
wishes to have counsel appointed, the court would consider or would appoint counsel to represent him in this matter. And he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where are
Do
your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish.
This is a
to
matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
until you
bench.
inform the court otherwise. Ms. Lundy.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time? on both
Well,
cases?
he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. There is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
the people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date potentially.
Because you've got to send it.
Yeah, and who restricted my phone
Probable cause
calls?
Conference, you know what?
Who,
You're gonna have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say. But I'm not gonna have you interrupt me and I'm not gonna have you interrupt the people when they're talking. As long as you were saying.
Thank you, Your Honor. I have to there's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that, and then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. as the bond.
Your Honor, I've been reviewing ex-jail and I wanted to double check if the defendant had been arraigned. It's not clear to me from a couple of different things, but it does appear that he has been set with a $10,000 bond in 25F30979, as well as 25F40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would like to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene from the sheriff's department in order to, for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel McGough. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem. going on. And I also think it's important for this court to know, because I don't know that the court knows, the defendant has a third new case, telecommunications malicious use with a domestic relationship, that is currently pending as well. He's also been set $10,000, 10% in that matter. But I think.
Where is that case out of?
That case is out of 14B, Your Honor, before Judge Washington.
Co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low. And I also am going to request a SRAM tether, because this is an OWI 4th alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was an abuse of discretion, given the circumstances of this defendant, to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
No
I
victims.
believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The police officer did not report that at all.
The court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash here. Thank you.
The tethers I requested, if he is able to post, Your Honor.
I will.
Thank you.
Thank you.
This hearing ultimately came down to one critical issue: risk. Throughout the proceeding, the court heard allegations involving multiple pending cases, prior failures to appear, accusations of fleeing law enforcement, and concerns about public safety. While the defendant maintained that the charges were invalid and repeatedly challenged the court's authority, the judge focused on the legal factors required when determining bond. In the end, the court sided with the prosecution and increased the bond from $10,000 to $50,000 cash in each case, concluding that both flight risk and community safety concerns justified a higher amount. Whether you agree with that decision or not, one thing is certain: this courtroom battle is far from over. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.